Hey everyone, welcome back to another episode of The Socially Distant Lawyer. I'm Mitch A's.
And I'm Greg Vinogradsky.
And here we are again, Greg, at the end of another year.
I know, we made it.
We made it. 2024 is going to be in the books shortly, and we're going to do our year-end episode again.
That's right, that's right.
It's been a good year around the firm. We've expanded, brought on a bunch of new attorneys, and new paralegals, legal assistants, and we've had a really good, solid growth year.
Yeah, we've been lucky. Every year it's been growth, and knock on wood, it continues to grow. We got a new office in Massachusetts. We're rolling.
Yeah. So thanks to all of our clients, all of our employees at the firm. It's been really great this year. And during this year, we talked about a bunch of topics. So we talked about Corporate Transparency Act. We talked about non-competes. We talked about structural integrity bills. We talked about the Grieving Families Act, the MS Dali, that disaster that happened. And we also talked about fraud. The fraud-demic. Fraud. That was a big topic. Right. So what we want to do today is just recap it for everyone and see where things were and where they're going. So why don't you start off on some of these topics, Greg?
Yeah, so we started the year talking about the Corporate Transparency Act. There was a lot of gray areas. A lot of people were unsure about who exactly fell under it, what needed to happen to comply. And really, that never really solved itself, right? Everyone still was pretty confused up until a couple weeks ago, and the deadline was approaching for December 31st, 2025. Every corporation that fell under this law had to comply. Well, there was a court case in district court in Texas, which kind of surprised a lot of people because there had been a lot of lawsuits, and every decision had been pretty narrowly tailored as to whether, yes, you fall under the Corporate Transparency Act, or no, you don't. It's federal overreach or not. And where it landed, amazingly, was a nationwide preliminary injunction was issued, staying all enforcement of the Corporate Transparency Act by FinCEN, as well as staying all requirements for compliance for all corporations that would fall under the Corporate Transparency Act. So I was literally sitting in a room with attorneys, and everyone got an alert on their phone, and everyone started notifying their clients ASAP, like, you don't have to register. Board members for condos that we're going to resign. You don't have to resign, right? Hang on. So we're going to keep talking about it in 2025 because this is just a preliminary injunction. And with the new president coming in, with Doge and Elon Musk and what they want to do with administrative agencies, we could see this entire administrative agency potentially wiped away, if not just this rule for the Corporate Transparency Act.
Yeah, so I think that's, and because it was going to go into effect starting on 1/1.
Yeah.
Right, so it was right. It's going to go in into effect real soon, and then it just got, the injunction started.
3 weeks for the compliance deadline, right? We had started ramping everyone up. Actually, a lot of condo associations started paying money to third parties to facilitate this process. So this was in effect, and as usual, last minute something happened unexpected, and here we are with it.
It'll be interesting to see what the new administration does if they allow this thing just to kind of die on the vine, so to speak, and not try to enforce it or
they might not even want to appeal it, right?
Right, they might not want to appeal it. The other issue we talked about in the beginning of the year was Grieving Families Act.
Yeah.
So that was one of the issues that we talked about in New York, and it hasn't moved. We're still in the same position we were a year ago. The bill was vetoed, as we talked about earlier in the year. And right now it's on the governor's desk again, a revised, trimmed down version. It was vetoed last time because of the concerns with higher costs of insurance, about a lot of corporate interest, as well as trying to protect consumers and the cost of rising insurance by expanding the wrongful death statute. That's what the Grieving Families Act was in New York. It was an expansion of the wrongful death lawsuit, which has been around for over 100 years, I believe. And so right now it's back on the governor's desk, a trimmed down version of it, trying to narrow down certain items of recovery.
When does she have to decide?
So she has until Christmas Eve again. Okay. Same time as last year. So 2025, we'll be bringing it to you again. 2025, our first episode.
I know the defense bar has really been pushing against this about expanding who can recover. Right. New York is already extremely litigious. So this would just expand that a little further, right? So.
Right. It would expand who can recover. The familiar relationship as to who can recover, what they can recover, better define it. It's got bipartisan support. It had it last time. It was still vetoed by the governor because of a lot of other competing interests, consumer as well as corporate interests. Yeah. So we'll see what happens in the next couple of weeks.
Yeah. Another big one for New Jersey that I've spoken about a lot this year has been the structural integrity and reserve study law as it relates to community associations. I'm not going to go into exactly what it is, but by now, if you can check out one of our other episodes that we've got in depth on. But where we are is really, it's really at a crossroads for this law. There has been some pushback because it's in effect, and associations have had to perform the structural inspections, get their reserve studies, and now it's budget season. So now they're looking at how much they need to contribute to their reserves. They're looking at their maintenance fees, and they're having a lot of questions about the law. Unfortunately, what we've seen is that there's been a lot of misconceptions about the law. And I don't know if any of that's been purposeful or not, but definitely there's been a lot of misconceptions specifically about what adequate funding means for the reserve study. Because the law specifically cites to the CAI, Community Association Institute standards for reserve studies, and the law really doesn't say what level you need to for reserve funding. So you need to go to a baseline funding is adequate for the law. The New Jersey legislator is attempting to rewrite some of this law, and frankly, we're pushing back a bit because we've spent years trying to get this law in place, and we've seen that it has been effective for the associations, and frankly, boards like it. A lot of boards like it because they've been trying to ram these things through, and they've been getting a lot of pushback by the membership, not understanding the impact for the reserve study in order to avoid emergency assessments, right? In order to avoid these, what we saw in Surfside, right? Those $200,000 emergency assessments that had to be paid in a short time period, and now you're seeing the market start to decline in Florida, right? Because they did not have this law in effect. We're trying to create this law to prevent those types of issues because we have a lot of the same ocean conditions and a lot of the same atmospheric conditions as Florida does.
So was that in a direct correlation to what happened in Surfside, or was that already kind of in the pipeline before Surfside?
No, that was from Surfside. When everybody had known in the industry that there had been significant underfunding of reserves. And there was a lot of gray area as far as what the developers that were building had to contribute to the reserves. And what that meant was that this is a can that kept getting kicked down the road until you're left holding your deed and somebody says you have to make critical infrastructure repairs. And suddenly you have to come up with all this money out of nowhere. And you should have had the mindfulness and the thought process to know that maybe this should have been covered beforehand, and it just never was. So now with this law in effect, once it really starts kicking in, once you see it live and in action, you're going to see people buying properties with critical infrastructure that has been funded for, and you're not going to get these emergency assessments. It's an avoidance of that pay now mentality that a lot of associations had, and that they've got stuck with.
Yeah. So it'll be interesting to see if the legislator decides to take that up again and try to pass it.
Yeah, and it's been a few squeaky wheels, right? There's not a lot of members, there's not a lot of people that are against it or have voiced opposition to it. It's just a few people, and legislators listen to their constituents, so they're going to try to make them happy.
So another issue we talked about was the bridge collapse in Baltimore.
Yeah.
We had Adam come on, our resident expert in maritime law. Yeah, so the only thing that we've heard about recently is that the government settled, DOJ settled for $101 million against the folks that were involved in this. So now I think it's going to get quiet as it proceeds to the court. And
I'm sure it'll take a while to wrap up.
Yeah, probably. And we'll bring Adam back on and talk about it some more next year.
Yeah, the other thing was non-competes. There was a lot of talk about, again, similar to the CTA, administrative regulations, administrative rulemaking, and whether the Department of Labor can promulgate rules that basically says you can no longer have non-compete agreements in your employment contracts. The federal court issued a ruling, again, really right before enforcement of the rule when it was going to go into effect. They ruled in August that this was overreach, right? You can't have a ban on non-competes. So that may again come up in 2025. As it currently stands, everyone's non-competes are still alive, subject to your local state rules that you have on this particular issue.
Yeah. And the last issue that we talked about a lot about the second half of the year was the fraud-demic in New
Fraud,
York.
fraud.
Fraud. That's a lot that you've heard out of New York for quite some time now. I think a new RICO suit was just instituted this past week, and it's an issue that started in 2024, an issue that started well before 2024.
Yeah.
It's come more to the forefront, more to light in 2024.
It's always funny because these things tend to start like with a viral moment, and I think one of the biggest ones in our industry was that the rear end accident, right? The staged accident where the person got hit and everyone walks out of the car like this, right? And they're hurt. And then they see there's a dash cam and then they all run away. Right? And that created a viral moment. And then from that, everyone's like, oh, wait a minute. There's a gigantic RICO lawsuit brought by insurance companies against plaintiffs' law firms and providers, right? That have been in the works for forever.
All it takes is that viral moment to set things off. So in a nutshell, check out our other videos on this stuff, our podcast that we've done. We even talked to Chris Delbove, our partner, who's spearheading the fraud stuff for our office. But this all arose initially out of workers' comp. During the pandemic, where the workers' comp treatment and fees kept going up, but a lot of places were locked down. So that's how they started to
It was something
put
so
these pieces
simple.
Together.
Yeah. How can you have so many workplace accidents when you're not allowed to open your work site, right? or construct anything?
So that's how it started. And then from there it evolved into, well, these accidents look like they're staged, and there's labor law cases that are, in essence, strict liability in New York. So that is an easy bar for them, for plaintiffs to prove. The strict liability aspect, if it happens on a construction site, generally defendants are liable. Defendants are taking a harder position and a harder look now into making sure that all of these claims have merit. So,
yeah, I think as great of a job as we're going to do on fraud, I think it comes down to the way the laws are written and really inviting these kinds of things and these types of frauds. If the law wasn't drafted, if those 240 scaffold laws weren't drafted the way that they were, and if the courts hadn't ruled in the way that they adopted some of the facts to those rules, you would not see this invitation for fraud that we're seeing right now.
And I think it also goes back to the courts in trying to assist on even the litigation funding piece, where the courts and the rules right now in state court in New York don't require disclosure. Federal court, though, has moved in the direction of requiring that as part of disclosures, the third-party litigation funding, which could lead into who else is involved in these cases. So who has a hand in these cases other than the parties that are involved?
Yeah.
It's just a wide open field, and there's so much information. The news media has picked it up. There's been articles. I think in the Times had an article. It's been everywhere lately.
Yeah, it's going to be a lot of PR. There's a lot of money at stake, and they're not going to go away quietly, right? A lot of these firms and providers and litigation funding companies, it's not like they're just going to go away because they're afraid of getting sued, right? So we have to get creative, we have to be assertive, and we have to be able to use our resources as well to challenge some of these, right?
Yeah. So I think 2024 we saw the institution of these cases. 2025, we're going to see if the cases develop beyond that initial 12B, the motion to dismiss stage, and if there's actual discovery, or is there going to be settlements? How much information is going to come out? How much is going to come out and come into the public light before the case gets either dismissed because of pleading issues, or because the defendants want to settle and protect themselves?
The one thing we're definitely going to do is keep track of it, get smarter with how to find it, right? They're trying to be one step ahead of us. We can't be reactive. We have to be proactive in identifying these issues. I know I'm excited when we're talking about some of these things internally and how to monitor these things, how to advise our clients on what to do, strategies to make sure it doesn't happen. It's going to be exciting the way I think that our firm and defense firms kind of attack these.
Yeah, and we've seen a lot of collaboration now across the defense industry, which is great, because the defense industry as a whole was not very collaborative.
Right.
Unlike plaintiffs' bar, which is very collaborative, and that's one of the great takeaways from them is that they share information. Defendants are now starting to kind of be more cohesive and coalesce around this issue. And so we'll see how this works in 2025 and whether that momentum on the defense side keeps up in order to match plaintiff side, who's been doing it forever, is that collaboration process. So that'll be interesting.
And we'll have Chris Delbove back to let us know the latest and greatest with what's going on there and what we're doing.
Yeah, so in terms of that, just stay tuned for our fraud reports. They're going to come out on a recurring basis as more and more information gets filed in the state courts and more that we hear, will bring Chris back for sure on some of that. So we've talked about these issues now that we've talked about throughout the year. Like we did last year, we're going to throw it down to some of our attorneys in our other offices that we have around the country and see what they're looking forward to now coming up in 2025 and what advice they have for clients.
Yep.
Thanks, Mitch and Greg. As a brief introduction, my name is Alan Rowlovich. I'm with the Florida office. 2023 brought a lot of significant tort reform to Florida regarding everything from a shortened statute of limitations, a change to comparative fault being modified, as well as a change to the evidence allowed in trial regarding medical billing. So what we saw in 2024 was the question of, do some of those new statutes apply retroactively or prospectively based on the date of the filing of the lawsuit? There was some initial excitement out of the defense bar. The judge in Hillsborough County in Tampa ruled that the statutes applied retroactive, so they applied to litigation that was ongoing even prior to the effective date of the statute. But recently, on November 25th of 2024, the Fifth DCA, in looking at the medical billing portion of the statutes, determined that the statute's intent is not to apply retroactive, and it determined that it only applies to lawsuits filed after the effective date of this act. This is the first decision that we see out of the appellate courts in 24. We do anticipate this issue continuing to being litigated in other DCAs, and if there are more favorable rulings for the defense that the statutes apply retroactive, we would hope that the issue gets elevated to the Florida Supreme Court and we can see a decision that has consistency across the entire state. So while these laws did go into effect in 2023, we continue to see how they're going to be applied throughout 2024, and we anticipate additional rulings coming into 2025. Thank you very much, and then look forward to seeing how 2025 works out for us.
Hi, everyone. I am Courtney Cargill, and I'm an associate in the Jacksonville, Florida office. As you may know, Florida law underwent major changes in 2023 with the Tort Reform Act. Well, it looks like our lawmakers were not done, because in May of 2024, and with an amendment in early December, the Florida Supreme Court approved the creation of one new rule of civil procedure and modified 13 others. The rule changes go into effect on January 1st, 2025, with some changes applying to existing cases as well as the cases filed after January 1st. Some of the more notable changes include a case no longer needs to be at issue before being set for trial. Within 60 days of service of the complaint, parties must engage in initial disclosures before any other discovery methods can be explored. And trial continuances are now highly disfavored and should no longer be granted. It appears the Florida Supreme Court is attempting to shorten and streamline litigation timelines with these new rule changes. Gone are the days of waiting and see for both sides. Parties must now be prepared to move quickly and efficiently towards a resolution. I am looking forward to seeing the new litigation strategies that arise out of these new rule changes, as well as the lasting effects of how we litigate cases moving forward.
Hey team, my name is Shivam Kumar, and I'm an attorney based out of the firm's Georgia office. Today, we will be doing a primer on OCGA section 91168, which is the code section for offers of settlement. In other jurisdictions, you'll see it referred to as offers of judgment. Under the Georgia code provision, there are very specific statutory provisions that must be included in the written offer of settlement to be a valid offer. We'll cover that in another video. For today, what I want to focus on is the attorney's fees provision of the 91168 statute. Under 91168, and for our purposes, a plaintiff that sends an offer of settlement to a defendant is entitled to recover attorney's fees if, one, the defendant rejects the offer of settlement, and two, the plaintiff receives a verdict more than 125% of their settlement offer. For quick numbers, a plaintiff who sends a settlement offer for $100,000 and then receives a judgment for $125,000 will be entitled to attorney's fees. Couple of things to keep in mind. First, a defendant can reject the offer either formally in writing or by providing no response. Silence is deemed as a rejection. Secondly, under 91168, attorney's fees will begin to accrue from 30 days after the party receives the offer of settlement. So keep that in mind as far as the timing. And the reason this is important to consider is because after March of 2022, when the Georgia Supreme Court ruled in Graham v. Jr. that parties are entitled to double recover attorney's fees under 13611 and 91168, there is a greater cause for concern based on the current state of the Georgia judicial system for double recoveries against defendants, i.e. against our clients, and as insurers against yourselves. So again, we just want to keep in mind the possibility of this double recovery of attorney's fees, and we also want to consider the timing of the solicitation of settlement offers from plaintiffs. The later that we can, get a settlement offer from a plaintiff in litigation, the more we can limit any potential damage should, for whatever reason, there be any recovery of attorney's fees. Again, team, really appreciate your time today. We'll be doing more primers like this moving forward, specifically including the requirements of Section 91168 for a valid offer of settlement, as on our side as defendants, we are similarly entitled to send such offers, and we'll cover other details of attorney's fees under 13611 and other novel concepts under the Georgia statutes and case law moving forward.
Thanks, everyone. Great information. We're looking forward to 2025. Looking forward to having you back on SDL as these issues continue to be addressed and more information is developed. Greg, it's been a good year.
Been a pleasure.
It's been a pleasure doing this with you. I think
High five. All
I
right.
think we're now 4 years running.
Yeah, we're crushing it.
And so looking forward to 2025.
It's going to be a great year. Thanks, everybody.
Happy New Year.
Take care.